didn't he? Where because rugby was on tonight, Hawthorn should have played last night, Collingwood should have played tonight, because the team that finished top should get the extra day's rest. Here we have a guy who's got 1 foot in the AFL camp and yet supporting rugby league. Is there any criminal offence of conflict of interest, or should football fans be able to take legal action against him, especially Hawthorn fans who are getting one day? Because of his conflict of interest, there is now Hawthorn are now getting 1 day less rest than they should be entitled. Well, I'm asking you as a legal man, not as a Carlton man.
No, that doesn't make sense.
That's not cause or grounds for... No?
No.
You sure?
Positive.
You don't want to think about it?
No, don't need to.
I reckon that's a conspiracy theory, worthy of an SEN caller. It's like Theo from St Albans.
Hey, don't tar us with that, bro. Now, another one for you, Charlie. In the States, this is about where's litigation going, where's suing going. Guy sued a popcorn company. He had 3 bags a day of microwave popcorn and finally got sick as a result of it. Sued the popcorn company, got $7.2 million.
You're kidding.
No. Are we heading that way too here in Australia? Is it getting that way?
I hope not. I haven't seen anything as stupid as that.
Popcorn's meant to be good for you.
It was the artificial butter that caused problems to his lungs.
I reckon
technical difficulties.
Yeah. I reckon the fast food PR legal fail of the week has got to be the KFC appealing that poor young girl who...
Oh, did they appeal that?
Oh.
Yeah, for the sake of $8 million or whatever it was.
What happened to her?
She had a... I shouldn't be talking about things I don't know the detail of, but she had a twister, I believe, KFC twister. I hope the Colonel's not going to be on my doorstep with a rib, but she had a KFC twister. She ended up having some sort of intellectual incapacity as a result of food poisoning type illness. All this we should say is allegedly because the Colonel's appealing, but I just thought for the sake of $8 million...
and bad publicity.
Is it a good... Yeah.
Well, hopefully the appeal court will double it.
Well, I don't know. I mean, you want the merits to be worked out, but just on a purely, PR sense. What was the Colonel thinking? And
in terms of our legal system, how long, if you were on the Colonel's side, how long could you delay actually parting with $1 for? Well, how many years can you delay?
No, it's not a given. You can look at the end of the day. The system, it's a civil system, so don't take it as being gospel from me. But from what I understand, you have to establish fairly quickly your grounds of appeal, not the merits, just that there is a specific ground to argue and point to a mistake that a judge may have made. And if you can't, in other words, you can't appeal just for the sake of appealing.
What about expert evidence?
Well, that's in what sense?
Oh, well, I reckon that would be the nub here, wouldn't it? The linkage.
Yeah, it's the link, but it's how the judge dealt with that evidence, which is critical. If he dealt with it in a manner which is totally unbeknown to the law, and saying, oh, that couldn't have happened, or it did this particularly happened, or something like that, then obviously that can give rise to appeal. The evidence itself is the evidence. There's nothing you can do about that.
I'm talking about the abuse of the legal system. So if KFC is this example, but any example, you have a huge judgment against you, let's say $8 million, and you go up to the person that won the $8 million and go, we'll give you $1 million now, or we're going to delay this for the next 10 years.
Well,
can you do that?
No, that can't be done. Because
why?
Because the civil systems, as I'm led to believe at the moment, are designed to keep cases moving, and also when you appeal, you have to justify your appeal. You can't just appeal on the basis of I want to appeal. You've got to justify it, and that justification.
KFC with its 400 lawyers will find some justification.
Well, they might.
You can only delay and delay and delay in Tony Mockbell style in the criminal area.
You can't delay in the civil area?
What are you talking about? Where's he going? He's sentenced. What's the point?
20 years in the making.
What's the point?
You can appeal right up to the High Court, though.
Not necessarily.
You have to have grounds.
You've got to have grounds.
Yeah.
You can't just appeal just for the sake of it. And the sentence, for argument's sake, Tony, right? He's serving a sentence which Gillard gave him, what was it, 11 with a 9?
Yeah, it was about 12 with a 9.
Something like that.
Okay.
So the moment he came back to Australia, that sentence starts. So big deal. He's in jail for at least 9 years. They've got 9 years to get it right.
His time in Bonnie Doon doesn't count against the sentence?
No.
That's like prison.
Time served.
Time served in Bonnie Doon.
But at the end of the day, he could appeal to the High Court. But his sentence, and his sentence continues.
No, but there's been a whole period that ignores the whole period when he's at large, and he's doing those things on other charges.
Yeah, but his sentence continues even to get to that point. Let's say he was appealing the cocaine sentence, and it was at the point of the High Court, and there was nothing else. That was it. The only one thing. He's still serving his sentence until the High Court says otherwise.
At the time of the cocaine trial, he was at large.
Yes.
Yeah.
He's on bail. That was the point.
That's right.
Yeah. So the fact once you're convicted and you want to appeal, your sentence commences and it continues on.
That's
so
right.
You can go for as long as you like.
We're arguing about pre-conviction and how slowly the wheels of justice turn if you delay in the pre-conviction.
As opposed to being on bail, as opposed to being already incarcerated.
Tony's case, as some of the other cases at about that same time, had one major problem in them. A lot of the information and a lot of the evidence that was being used in court came from that other bloke. And that other bloke...
Suppressed.
Yeah. That other bloke was creating havoc through the justice system. So realistically speaking, it wasn't their fault that it took so much time. It was the prosecution's problems with that other whacker creating the issues.
Speaking of the slow justice system...
And hold on, the slow justice system is not that slow anymore. It is getting faster and faster, and the judges that are in court now, in the county court and the Supreme Court, are very much acutely aware of moving it on. So
what about the Magistrates' Court?
What about them?
Well, I take every parking and speeding ticket to court, right?
That's your problem.
Yeah, hang on. And what they do is they make you turn up the first time. You think you've got a hearing, but it's a mention hearing.
That's right.
Where they want to hear if
you didn't read the fine print.
Hang on, they want to hear if you're pleading guilty.
You didn't read the fine print, Headley.
And then the second hearing...
No, but seeking adjournment, Headley, you'll get it. That's
hang on a second. You go to the second hearing, you think that's the hearing. No, it's a contest mention where they want to hear if you're pleading guilty or not.
I'm terribly sorry, our barristers can't match dates. We're doing something else.
So then finally, the third time you go... So they're making you turn up 3 times to the city for a fucking parking ticket. Hang on a second. You used to be able to ring up and go, I want to plead not guilty and not have to turn up. Right, they've stopped that. So they're making you turn up 3 times... for a parking ticket to plead not guilty twice before you have the hearing. Now, they're abusing the system to dissuade law-abiding citizens like me from taking the matter to court.
If you were to take a Tony approach, you'd turn up and you'd seek an adjournment. And when they forced you back to court, you turn up, you'd take another adjournment.
I don't want an adjournment.
They forced you back to court.
I want the hearing. I want to cross-examine that parking cop in the stand.
Headley, there's one easy way to fix it.
Yeah, go on.
Pay the fine.
I don't want to pay the fine. I want to drive them nuts. They drive me nuts. I want to drive them nuts. Why do you need 2 mention hearings before you have the hearing?
Read the fine print.
Yeah, but why do you need it? You don't need it.
But then you turn up and you say, I'd like to represent myself, but I'm waiting for legal aid approval. And we'll send it away for it. We'll send it away.
That won't happen either.
No.
Legal aid will not approve anything that relates to a traffic offence.
Won't they?
No, as of the 1st of October.
Really?
Yes.
So you're on your own?
On your own.
Yeah, well, you want your day in court, but you don't want 3 days in court.
The media person from the
police
a minute ago, where she said the bloke was clocked at 180 k's along the Eastern Freeway, 0.14.
And you said you could do nothing to help him?
Probably
he can take his money.
But at the end of the day, if he goes to court, he should be charged with things like speed dangerous, a couple of other bits and pieces, maybe conduct endangering serious injury. Manner dangerous. They all attract jail sentences, right? They can on the legislation. They attract jail sentences, and quite a few people these days do go to jail for that sort of thing. Legal aid, as of the 1st of October of this year, does not grant legal aid for those offences.
Really?
So they are left on their own. If a bloke comes to me and I can take legal aid or do legal aid, and he says I want legal aid for this, I said I can't do it. Okay, unless you pay me my money, I cannot do it on legal aid. And if he hasn't got the money, all right, what do? Go and see the duty solicitor. And the duty solicitors...
Oh, you just do a pro bono.
Oh, yeah, go on. You do your job for nothing?
Next to.
Oh, yeah, right.
And on that note, we will cross for the final time to Studio 2. Thank you, Dee Dee.